direction to the department side, my lord, education, to file an affidavit, starting from 20, item number 20, my lord.
Hmm.
Now, we have been told, my lord, no affidavit is filed till now.
No, we are
that-
filing it during the course of the today lawsuit itself.
But even if that be so, my lord, may have to be given an opportunity, my lord, we'll require some time to go through it, my lord.
You're filing your counter affidavit in the IA or in
Yes.
the main writ petition?
So it is a main petition lawsuit.
Or in the writ?
May Nitra already affidavit was filed.
Well, I think I
It has to be IA, my lord.
Unless they are filing it in my writ petition, because that is a fresh writ petition challenging that.
Yes.
that I'll look into lawsuit.
One affidavit or
Yeah, one affidavit.
only one?
One.
Okay. It is submitted by Mr. SMT History Learned Standing Council, Secondary Education, that an affidavit is being filed on behalf of the department in these matters today. Stop. Mr.
It's elementary education lawsuit.
for elementary education. Mr. Learned Councils for the pensioners, you give the names in the respective writ
Yes, my
petitions.
lord, will.
Submit that they require 1 week,
One week should be
2 weeks.
But actually, that will depend on the
contents of-
contents of the affidavit. my lord.
Two weeks.
Submit that matter, they be permitted some time to complete their instructions on the affidavit, which the department is required to file today. It is submitted at the bar, the matter be listed after 2 weeks.
Yes, Your Honor.
Hmm. 5th of March.
Right.
5th of March.
Yeah.
My-
Matters be listed on 5th of March. Item number 20, from
So-
20 to
45.
45. The whole
45.
series.
I am in 45.
20 to 45.
কোনটো হিট থাকে আইএট ফাইল কৰিব লাগে আইএট কোনটো ইন্ডিয়ানলে কৈছে ইন্ডিয়ানটো ফাইল কৰিব লাগিব বুলি কোনটো সেম সেম হ'ব
All right.
ইয়েস অবলাইজ হ'ব
Much obliged.
আজি ফাইল কৰিব
My lord, I am praying for listing matter, my lord, pension matter. My lord.
What
On-
matter?
Only 23rd, my lord.
What matter?
Pension, my lord.
Pension.
Yes, my lord. On
Uh,
23rd, my lord. Friday, next Friday.
Let it be on 1st of March. 1st of
Public.
March.
Non-payment of salary matter, Lordship.
1st of March. Yes.
Yeah, praise the Lordship. I want to withdraw a writ petition to file it before a proper authority.
Have it tomorrow.
Yes,
Give the numbers.
highly obliged.
My Lordship, I beg to mention for listing order, matter of last post.
1st of March.
matter relates to revision of pay matter. On the last occasion, my lord, the counsel for the APDCL, he admitted that these matters are covered by my lord, order dated 3/11/22, my lord. Before your lordship on 22/12, he did not accept, my lord, but on 5/1/2024, my lord,
Hmm.
he has accepted, my lord, these matters are covered by 3/11/22, my lord. Ordership may be seen, my lord.
Lordship, this matter was fixed today because there was a meeting of the Joint Consultative Committee, which was to sit because the pension fund, your Lordship, as it stands today, it does not have enough funds to meet the pension claims of the petitioner, then other cases which will arise, your Lordship. So on that account, on that submission, your Lordship, the matter was fixed today. But because of the assembly sessions, your Lordship, the three chairmen of
Whatever funds you require, you ask for it. But what is the direction in the judgment?
in that judgment, it was, the finding was that if a person has retired on 31st of March of that particular year, he will be covered by the revised pension scheme. That is under appeal before a division bench.
Whatever it may be.
So Lordship may kindly give us some time, your Lordship, so that
No,
we
my
can
lord,
at least.
to dispose of.
No,
today,
this
my lord.
is.
No. Which judgment you are referring to? Mukud Das.
Yes, my lord.
Mukud Das.
Yes. It is covered.
What is that- what is that-
Also, my lord, there is
What is the division bench judgment?
Division bench says, my lord, that in the case of, if the division bench says, my lord, if the repeal is allowed, my lord, in that case, my lord, we have to give it back, my lord. That right there is there, my lord. That has been mentioned, my lord.
No, but division bench has held that it is covered by
Yes,
judgment.
yes, my lord. So when
What the division bench
Annexure
held-
M order may be passed, my lord. Annexure M, my lord, totally, everything is mentioned, by Annexure M, page 52, my lord. That is the order that can be passed easily, my lord.
Lordship,
Earlier,
at
this
this stage, your Lordship, even if such a direction is passed, your Lordship, because of our present financial situation, this order would be.
No problem, my lord, no problem, my lord. That
So
is not a problem.
Submission perhaps should not be fall from my learned friend that he is asking for an unimplementable writ, your lordship. What I am praying for, lordship, may kindly, if on the next occasion, lordship, I will have some instructions, your lordship, the committee will sit.
No, no, what we want to know,
Yes, your lordship. And on that submission.
there is a submission recorded
Yes,
by
sir.
the standing council
Yes, sir.
that it is covered by the judgment and order dated so and so passed in WPC 1607.
Yes, your lordship.
Now, the prayer of the petitioner is that this matter needs to be disposed of.
Yes, your lordship.
Your submission is that against this order, there is some appeal which was filed.
Yes, your lordship.
And according to you, the matter is still pending.
The appeal is pending before a division bench.
No, but it appears that the matter was disposed of.
Writ appeal 107 or 2023, your lordship.
Yes, that is disposed of.
Appeal is pending. I have
Oh,
been.
is it? It's pending, okay,
It's pending, your lordship.
okay.
So,
So whatever orders the appellate court will pass, will govern it.
Oh, that has been mentioned in the order.
lordship, the issue.
Now, what, in view of this order, can there be a different decision taken by the board?
No, your lordship may pass that order, your lordship may just grant me some time to place. I understand, your lordship, unless it is set aside by the division bench or interfered with, your lordship will perhaps be.
No, what instructions do you want to place before
The
the court?
position is that, your lordship, my instructions are that if the claim of the petitioner and people who are similarly placed like him are allowed, your lordship, there will be a additional financial burden of almost 22.5 crores, your lordship. And the pension fund of the AACB, now which has been trifurcated in amongst the three organizations, successor organizations, that does not have enough funds at the moment, your lordship, to meet that financial requirement, your lordship. So a joint consultative committee of the chairman of all the three organizations is being convened, your lordship. It was supposed to sit on the 12th, but because of the assembly, it could not sit.
No,
So
for what purpose?
So that we can make some, at least we can take some decisions about whether if we want to go to appeal or request the government for additional funds, your lordship.
No, the appeal is already pending.
Yes,
Because the appeal has been filed by another organization, not by us, your lordship. That in that writ petition which my learned friend is referring to, it was an appeal by the Assam Power Generation Company, your lordship,
That's right.
APDCL, not the APDCL.
Uh,
That was in that order
And
was passed.
they're employees of where?
They are now this
Now they are
petitioner is
APDCL, all the trees are covered by this revised pay skills.
they are those
All are
and
covered.
that
No, you are
petitioner was
employees of generation,
APDCL, man.
APDCL
APDCL, man.
distribution.
distribution,
ma'am.
and that was by generation, your lordship.
All revision pay rules are, my lord, applicable for 3 wings, my lord, all 3 wings, my lord. It is not that, my lord, something will be different in case of APDCL or AEDCL, my lord. My humble submission is that it may be disposed
So
of.
my instructions that the meeting is going to be convened within 2 weeks, your lordship, may have the matter after 3 weeks.
Already
on-
4 weeks' time has been given to them, my lord.
I do
Their
not understand
assurance,
what
all
my
their
learned
assurance,
friend-
my lord.
What my learned friend's hurry is that it should be disposed of today itself, your lordship.
Yes, yes, yes.
This is being,
No, there's no hurry, but we don't see once the council has agreed that this matter, the issues raised stand covered,
yes,
what is the point in keeping it pending?
your lordship, that
Subject to making it outcome of any appeals that may be filed.
perhaps your lordship, I understand your lordship, because if it is identically placed, then it
Then-
might be covered. But
And more particularly when you say that this appeal is not preferred by the APDCL.
the appeal is not, APDCL, appeal is not preferred because that matter involved an employee of the APGCL.
Hmm.
So the appeal was preferred by APGCL, your lordship. Now, in the present case, the petitioners here are former employees of the APDCL, your lordship. So we are only submitting that let the meeting of the joint consultative committee be convened, your lordship. Some decision will be taken and then an order can be passed, your lordship, which will take care of this aspect as well, your lordship, about the paucity of funds. Otherwise, your lordship, I am not saying that because the order of the coordinate bench stands, your lordship, I have to bow down before your lordship. But some time may be granted. On the next day, your lordship, then order can be passed.
That was the submission on the earlier occasion also, man. Same thing will happen again, my lord.
This order was passed on 3/11/2022.
Yes, the
Yes,
meeting,
fine.
As on date, you have not filed an appeal. As on date, no appeal has been filed this is not against the APDCL,
this is not against the APDC.
right?
And the meeting was supposed to be held on 12th, your lordship. It had to be postponed because of the assembly session. So I have been instructed that it is going to be held within the next 2 weeks, your lordship. So the matter may be listed after 3 weeks.
What is your prayer here in the writ petition? Correct revised pension.
Yes, my lord. As has been granted to in other writ petition, my lord. That will benefit them only 2,000 or something, my lord. That will be the difference. Humble submission, but even
he's
if it
saying
is
19
disposed of,
lakhs
my lord,
eighty-
there will not
He's
be a
saying
problem
19
for
lakhs
them, my lord.
85,000, your lordship. Sorry.
I have been instructed by my clients that there is no cracks of, because they are all from finance and accounts department, but all the employees are my lord.
No, lordship, I understand he might be from the finance department, but at this stage, if we cannot implement the order, your lordship, then tomorrow the sword of contempt will be hanging over our necks, your lordship. So that is why I'm saying that some time may be granted, your lordship.
In any case, Mr. Mukhtar, probably if we have to dispose of in terms of this order,
My lord.
then the views of the department would again be necessary by way of an affidavit
They have, my lord, say, covered, stated in the last order, my lord.
covered in terms of the issues. But the factual issues may be different slightly.
Absolutely not, my lord. In that case, my lord, it will, my lord, I think it will take a lot of time, my lord. Because if your lordship allows them to file affidavit, my lord, in that case, my lord,
So we cannot prevent them from filing.
well, that is true, my lord. But why they have not filed till then, my lord?
They have not
Notice has not yet been
They
issued.
have not filed. We have granted them time. They have not filed.
They could have filed, my lord. No, it is not necessary that notice should be issued, my lord.
Under the
They
High
are
Court rules,
appearing,
it
my lord.
is.
They are appearing, my lord.
No, maybe, but we are bound to issue a notice at least for disposal.
But you also fix a particular day on that day, but if they don't come with any
Third line.
factor, my lord, it will be disposed of, my lord.
Parties issue notice returnable on 5th of March.
My lord.
Mr. KP Pathak, Learned Counsel, appears for the
All the responses.
all the respondents.
2 and 5, I may.
Oh,
It is submitted
no, 2 and,
for
okay, 2 and 5 I am
2
not
and-
appearing.
2 and 5
That is
I may-
APGCL again.
1, 3, 4. Mr. KP Pathak and Mr. D. Nath for 2 and 5.
Yes.
It is
2 and-
submitted by the learned counsel to the petitioner that the issues involved in the writ petition stands covered by the judgment and order dated
3/11/22.
3/11/2022, passed in WPC 1607 of 2020. Stop Mr. Mukhtar, learned counsel to the petitioner, submits that he said writ petition was preferred by another employee of the erstwhile AACB who had retired, who had superannuated from the sister concern of the respondent organization, namely Assam Power Generation Corporation Limited.
Company.
It says corporation,
Company.
company limited.
It is Assam Power Generation Company.
No, distribution, but generation
Company.
company,
Company.
generation company limited, who is represented by the respondents number 2 and 5. Learned counsel for the petitioner, relying on the said judgment and order passed by the coordinate bench, submits that this writ petition can also be disposed of with similar directions granting the benefit of the revised pay rules of 2017. Stop. Para Mr. KP Pathak, on the other end, prays for further time to complete his instructions as he submits that a meeting of
The Joint Consultative Committee of the chairman of the 3 organizations.
the joint consultative committee of the chairman of the 3 companies was scheduled to be held, which was deferred because of the ensuing
Budget session of the assembly.
budget session being carried on in the assembly. He therefore submitted the matter be deferred for some time, enabling him to obtain the required instructions and place the minutes of place the decision taken by this such meeting before this court.
And never shall be made.
In such view of the submissions made, matter be listed again on 5th of
March.
March. Extra copies, if required, be furnished on the
One
respondent
copy I have
count
submitted.
All right, it's all right.
within the course of this week. List on 5th of March, an attempt will be made to dispose of the writ petitions on the same date.
Deeply obliged.
Obliged.
Item 2 and 3 similar.
Same.
Similar respondents,
Similar respondent.
same order in item 2 and 3.
Obliged.
Yes.
Lordship, item number 4 may be taken after some time, my lord. Dr. Asaf Shah will be in court number 1, my lord.
4 to 12.
4 to 12, my lord.
All right. 4 to 12
Obliged, my lord.
after some time.
Lordship,
Yes.
Lordship, I am for the respondent in this case.
Who's for the petitioner? None appears for the petitioner on call. Your Mr.
M.K. Das, Lordship.
M.K. Das appears for the respondent. ONGC,
Your Lordship,
matter stands passed over for the day.
obliged, Lordship.
Yeah, please. Lordship. Here is the last order.
My lord.
Yes, Mr. Talukder.
Lordship, the petitioner's service was regularized after 1st February 2005, Lordship. As such, he is not entitled to any GPF account, my lord. Opening of GPF account.
You are regularized, you are appointed on which date?
My lord, my initial appointment was on 1996, that's 18/3/1996.
Hmm.
Against a valid sanction post on temporary basis. And that was Lordship service regularized with effect from 1/6/2013 against the same post. Because that post was created in the year 1993.
So this is after NPS.
Yes, Lordship.
My lord, so far the earlier period of time, Lordship, my lord, that period should be counted for the purpose of pensioners' benefit.
So then you'll have to challenge the regularization order.
No,
Where is the regularization order?
Lordship, that is space, Lordship, 57. My serial name, Lordship, at serial number 48,
48.
my lord. Page 58. The post were originally created by government letter number 7/1993. Lord. Against those posts, Lordship,
Now, is this under challenge somewhere?
no, Lordship, I have no knowledge of whether someone has challenged it or not.
No, you.
No.
So
My lord,
your order, this will have to be challenged
my lord,
by the.
for the purpose of pensioners.
That's correct, but then there has to be a finding by the court. You
Right.
want us to return a finding where this is not even assailed. Is it assailed here?
Oh, lordship, SL, that may not be lordship.
You see,
Because,
you want a finding that this should be counted for the purposes of pension.
my lord,
There has to be a finding
my lord,
on the basis of the order which has been passed.
my lord.
You'll have to, the respondents will have to be given an opportunity to respond, namely the Panchayat and Rural Development.
My lord, may I, lordship, draw your lordship attention?
Yeah.
In the affidavit filed by the lordship, department lordship,
Yes.
just paragraph 11. Out of 51 lordship candidate, 10 were given GPF and some of them lordship are getting pensionary benefit, pension. Pension and other-
Sorry.
Out of 51 lordship, all the 51 candidates were regularized with the same order. They were appointed in the similar category. And out of lordship 51, 10 were given NPS. As per lordship affidavit given by the lordship, the
By
department
whom?
lordship paragraph 11 lordship.
This is filed by whom?
And by the lordship, respondent number 4,
PNRD department.
PNRD department lordship.
Uh,
Paragraph 11 lordship, may I read lordship?
so you fall under the 32,
Now lordship, no. I am in the 9.
9.
32 are given NPS, 10 given GPF, and 9 lordship neither GPF nor NPS. Lordship, well, it is the regularization order page 57, serial number 3 lordship. Now let page 57 in the requisition. Serial number 3, Dhiren Talukdar. Well, he retired from service and he has been given the pension and other benefit lordship. I have the copy of that.
PNRD.
It's not a case that there is no break lordship from 1996. We continue.
Who
And,
for the
it-
PNRD department?
Yes, Lordship, PNRD has to.
Where is PNRD?
Lordship, can it be passed over for the sometime, Lordship?
Why the councils are not available? There are a set of standing councils. Matters are called up as per the cause list. It indicates there's a standing council PNRD in the cause list.
Yes.
Yes.
Then standing council PNRD Matadi.
Can it be at 2 p.m. lordship?
2 p.m.
2 p.m.
All right, 2 p.m.
I will inform him lordship.
Standing council PNRD. Hello.
Okay.
Yes.
In fact, this matter was heard by your lordship, and I have given a short gist of the case. That case, my lord, the penalty order will not affect my seniority. Item number 17, my lord.
1 minute. 17, that is 8036.
Yes, 803.
8036. That, do you have that list of the synopsis? Do you have it again?
I have already.
It's not here. You already. Oh, already, I mean, already. Yeah, believe it. It's not here. We have one in, yes, 8036.
8036.
Yes, yes, we have it. It's in a different file. Thank you.
Controversy is.
Yes.
Controversy starts from page 120. This is the conclusion part of the order imposing punishment, penalty.
120.
Yes, madam. Paragraph 10.
Yes.
Reduction of pay
For 2
by 2
years.
stages for a period of 2 years is imposed upon so and so. With a further direction that he will earn increments of pay during the period of such reduction, and on expiry of such period, reduction will not, that is important, my lord, have the effect of postponing the future increments of his pay. Now the guiding rules are, my lord,
Hmm.
page 128. Page 128, last paragraph. Small Roman 2. How should the seniority of such government servant be determined on re-promotion? That is the issue of discussion, my lord. And the conclusion, lordship will find at page 130.
Yes.
130 after serial number 3. In case where the reduction is for a specified period and is not to operate to postpone future increment. Here in my case, increment was not postponed, my lord. The seniority of the government servant may, unless the terms of the order of punishment provide otherwise, be fixed in the higher service and grade or post to the higher time scale at what it would have been, but for the reduction. So he will get back the seniority after the in fact, a honorable ethics court judgment is also there on the subject matter. Order of punishment is 31st of December 2013.
See, the punishment is with regard to reduction of pay
Lordship,
for a period of 2 years.
subject to not disturbing his increments.
Ah,
Here, Lordship will find reduction of pay by 2 stages for a period of 2 years, with a further direction that he will earn increment. So it's a minor penalty.
so after the promotion, after the penalty,
Lordship,
your case was considered for promotion.
yes, my lord, and I got
And
the
that promotion was not given because the 2 years did not elapse.
Lordship,
Subsequently, you were promoted.
Lordship.
But your case is that your promotion, your seniority
Seniority as it was
earlier, had it been
Earlier.
considered at the time when it was deferred? But on what basis are you making the submission?
Because of this office memorandum. my lord. In fact, the wording of the office memorandum has been used.
Office memorandum is at
Uh, It is 128,
128.
10th of October 1960,
What is 126?
126 is another office memorandum, no? Same line. This is 2007. The original office memorandum is of 1962. It was relating to two doubts, my lord. Page 128.
But there was a direction for reduction of your increment,
Pay,
but not seniority.
not senior. That
And
is
then-
why, my lord. Seniority has got nothing to do in this case with the, so far as penalty is concerned. But what happened during these 2 years, my seniority has been disturbed.
What does FR uh, what is that? FR 29. What is it? FR 29. The TCS. FR.
May I please, my lord?
FR 29-2, 1 and 2, man.
Yes.
That has been referred to in at page 128.
Do you have a copy of the CCS rule? FRSR?
FRSR has been quoted, my lord, at page 28.
No, no. Do you have a copy?
No, no.
No, no. No, you wanted to say something, yes?
My lord, I'm requesting this matter to be kindly taken up at 2, my lord.
Why?
My lord, actually, just today morning I have arrived because I was out of session and I could not go to. My lord, may kindly fix at 2.
No, no. 2, we have fixed other matters. 2, we have already fixed other matters.
Then, my lord, tomorrow.
Tomorrow, we don't know tomorrow. Saturday, we can have it.
provision of the FR has been quoted, my lord, at page 128.
So provision has been quoted. We want to see what FR says.
Lordship.
What you're saying, what you're trying to interpret is because of the punishment,
Lordship.
although the punishment is not in respect to reduction of your seniority, is only for stoppage of increments for 2 years, your promotion due was not considered because the period of 2 years did not elapse. Now, after you are considered for promotion, obviously you'll be junior to the people who were promoted in the earlier round. You want your seniority restored
Restored.
by virtue of FR 29.
Yes, FR 29-1 and 29-2.
So we'll have to see that FR. Right? Saturday কিমান আছে? Huh?
শনিবার খোলা আছে।
Okay, let us see if we can take it up at 2. If we can, we are not commenting. We'll keep it for 2. Let him be available for 2.
Lot.
If possible, we'll take it up.
In the meantime, I will get the FR.
Yes, FR is necessary because we'll have to go through that.
All right.
Please be available, Mr. Dekar.
I shall be able.
Have you submitted? This is otherwise hard. This
Hard.
matter has been hard.
Hello, my learned friend has prepared a note, my lord, a bit bigger,
Ah,
but the first page covers the, my lord,
Factual.
facts. And the second page, half paragraph contention of the respondent. Otherwise, on elaborately, date wise also.
Very well, very well. Yeah.
It has been filed and
File.
we did it.
Very good, file.
We did it. Well, I'm giving a copy.
Huh.
I'll give a copy.
Yes,
Only that 2012 TSCC that farmer case, my lord. I'll give a copy extra.
We have noted it.
Yes.
You can give us that synopsis.
Synopsis, sir.
Anything to submit?
They've given that.
Our record already.
Translated copies are here.
Yes.
Yes. Very well. Hard disposed.
That willfulness is not there.
Yes, yes. We'll examine that matter. We reserve it for judgment. Yes.
Man.
You done it. Huh? 15. Lagi dulu.
May it please your lordship. Lordship, according to the last order, they have to file additional affidavit.
Hmm?
According to the last order, lordship, they have to file additional affidavit.
Lordship, we just have received lordship. I have placed before your lordship. We were instructed to get the instruction only regarding the. But the labor department, they have forwarded it lordship, but they have also stated that the wages is again scheduled for changes lordship. So they have given it the earlier one. Private agency. Okay, for employees working in private security agency, the state of Assam. This one. এখন আবার change হয়েছে। প্রথমে জুলাই জানুয়ারি হ্যাঁ মেইলে রেখে হচ্ছে দিলে দিলে this is the present wages per month. হ্যাঁ সেটা but there also the private
What is the meaning of this? Due for revision? Not yet revised.
Lordship, it revises every 6 months, Lordship.
So when is it likely to be revised?
Yes, it's likely to be reserved.
Whatever is existing, you give them.
Yes, Lordship. This is the existing one, Lordship.
On the
Which
next
was of
page.
July 23, Lordship.
First of,
Lordship, page 1, 2, 3. Lordship, on 4th page, this is the notification, Lordship.
1st of July 23.
Yes, Lordship.
It should have been revised by 6 months.
After 6 months, Lordship, that's why they have stated.
Hmm.
It's about to be revised, Lordship.
Hmm.
I think by this month or by the next month, this will be revised, Lordship.
So
If it is July,
whatever-
I think by 6 monthly, Lordship, these are revised.
whatever revised, they're
Now it is
propagated.
due, Lordship, for
Yes.
revision.
Yes. And what is in by the notification 2411?
2411, Lordship. Yes, in continuation of previous notifications, so and so employees following the schedule employments are fixed on the basis of 100% rise on average all India General Consumer Price Index for industrial workers. Base year 2016, Lordship. And the table is there, who comes under this, Lordship. These are unskilled, semi-skilled, skilled and highly skilled. These 4 categories
Yes.
are there, Lordship.
What do you submit?
We haven't got this till now. This, we need this. Lordship.
What?
Yeah, this Lordship.
Who's for the Oil India?
Well, I am for respondent number 3.
What do you submit?
Well, they are actually village defense worker.
Right.
Their terms are regulated under a separate act. And as per the provisions of that act, my lord, the wages are being determined. They are asking for a comparative parity as per the provisions in the minimum wages act. But the minimum wages act do not apply to them at all. They are asking for a hike in their payment and wages. For that matter, in the division bench, there is a matter pending, my lord, in which they have challenged the provisions of this, of section 10 of this act. Section 10 of Assam Village Defense. Section 10 of Assam Village Defense Organization Act.
Is it available here in the pleading somewhere? The Village Defense Act.
No,
Village Defense Act doesn't it?
I have a copy, my lord, your lordship can.
Yes, certainly.
Their regular remunerations are regularized under the provision of this act. And now, after knowing that this is the hurdle on their way, my lord, this act has been challenged and that is pending before the Honorable Division Bench.
Clause 10.
Clause 10. Section 10, your lordship will find at page 324. Has been enough to 100. Number to and the provision of this act has been challenged, my lord, in WPC 4062 of 2019. Oh, 13. Right.
Even the division bench has held that they deserve a hike in their honorarium.
Yes, but the obstacle on the way is section 10. And therefore the
No,
matter
but
is,
section 10 does not prohibit them from getting, they will not be entitled to a remuneration, but
yes. Now, in this writ petition, my lord, they are asking for a hike and a parity in terms of minimum wages act. Now,
but they may be suitably rewarded as prescribed. Now, how the reward is to be conferred?
that is up to the government
That's right.
or the
That's
agency which employs them. The agency which employs them is the Assam Police. Director General of Assam Police is the.
No, it can't be the agency. It is a part of the government. It's a
Yes.
department of the government.
No, what I mean to
The
say is that
agency employing them is the Oil India.
no,
You're expecting services.
No, we place our requisition before the police,
Right.
and in turn, police gives appropriate appointment to us.
Why do you want these VDPs to guard your installations? You have the industrial security forces.
No,
at
that
your
we
disposal.
do. With our installations are taken care of by the industrial security forces
Hmm.
and also the Assam Police.
Right.
Now, whenever, because there is a shortfall in the manpower in the Assam Police, so at times Assam Police sends them as our to fulfill our requirement. And the payment that we make, it goes straightway as per the.
No, but see, you are extracting some service from somebody. Now, whether the government wants to pay, does not want to pay is a different issue. But the requirement is essentially at your request.
No, it is also not that every time we require their assistance or require their service. At times it is seasonal, at times it is depending on the.
What installations are they guarding?
They usually
Pipelines.
take care of pipelines.
Pipelines. How can you say it is seasonal? It's a pipeline passing through.
Sometimes it is also the well heads. In our affidavit also we have
Oil heads.
well heads. wellheads as well as pipeline, and depending on the necessity, because why I am saying seasonal, because there are other security forces, industrial security forces, people are available. And they are not in preference to those regular employees. Only when there is a shortfall of the pool, then the Assam police sends them.
Yes.
So anything that requires to be done in the case, my lord, my humble submission is
Has
that
the government filed their affidavit?
government diya na na. So perhaps the government's affidavit is not there, but we filed an affidavit, and basically we have challenged the maintainability of this writ petition also.
But government's affidavit is necessary.
SP Dibrugarh have filed one affidavit, Lordship.
Huh?
Respond number
2.
2. SP Dibrugarh. In paragraph 5, Lordship.
And on the face of challenge in the writ petition, challenge to section 10, pursuant to your lordship's direction therein, the superintendent of police had revised the honorarium and there was a hike. এগুলো কপি আমার ফেলত নাই তো লোক কপি করতে হবে
Under what provision is the SP saying that they are to be paid pocket money?
Yes, Lordship. VDP, that's a Village Defense Party, Lordship.
Correct.
Then the Village Defense Organization, they have to make party and we have to obtain instruction from them, Lordship, what is the existing term of payment, Lordship, not the Labor Department.
No, your SP has filed.
SP has filed, Lordship.
So
And he has
SP
categorically
has
stated
made a
in the
statement.
VDP, yes.
SP has made a statement.
Huh.
They are to be paid only out of pocket money.
Yes, Lordship.
What is this pocket money
as per
concept?
amount allotted by the government.
Then
So there is some
they are not saying that they have been deprived of salaries. They are saying that
Yes.
whatever wages, remuneration, you have to enhance it. You are paying 500 rupees per month for a job.
yes, Lordship.
Either you say that they're not doing their jobs as per the requirement.
Lordship, I can obtain an instruction from the Village Defense Organization, Lordship, from here, the main office. What is the present pay structure of the, that means the payments made to the Village Defense Party, Lordship? Otherwise, the what notification that I have obtained, Lordship, this will have no.
You are arguing the matter or there's somebody leading you?
Lordship, R. Mohinder, sir,
Where is he?
he is on Lakes, Lordship, report number 1.
Now, in view of a challenge made to the virus, all right, you call him. We'll take it up after a while.
Okay, Lord.
Call him. After a while,
or at 2, my lord.
already half the matters are fixed at 2. So it may be earlier for you before 2.
Or next any other date.
Let us first find out what they have to say. That's all. Find out what is the status, because they are challenging the virus of the section itself, as you say, and the matter is
Yes.
pending.
Yes.
Whether we should hear the matter or await the decision of the division bench. And if in the meantime there is some hike, it can be paid, then the matter can also be closed with the limited direction.
Well,
Their
the
prayer
same-
is for regularization.
well, the same set of petitioners are also there in the division bench.
They're challenging the virus.
Yes, challenging the value.
Now, this
And-
is not a
and-
case of. This
And
is a
one
case
of one of my submissions would be that on the face of provision of section 10, which says that there will be bar on remuneration, well, this prayer in the writ petition cannot be gone into unless and until my lord the
bar on
division.
remuneration is there, but they may be suitably rewarded. That is the
Yes.
mandate of the section.
Yes, but on this there will be also another issue of whether they can maintain the same prayer before the two forums.
How
so
can
to
it be
say.
same prayer? It's a virus of the section.
There also they are asking for the same relief.
Additional
which is-
prayer, but primary prayer is virus of the section. Here the virus is not put to challenge.
But then how to claim minimum? Because one of the contention is to grant them parity. as
We do
per
not
the-
know how the division bench will deal with it, but once the virus is challenged, the question is whether the validity, the very question of the issue regarding the validity has been put to challenge.
No, well, they are saying.
Now, if the division bench allows the writ petition, validity, if the section is interfered with, interpreted or set aside, consequential orders will follow.
Yes,
If
but
the division bench rejects their prayer, then whether they press for an alternative prayer of giving them minimum wages, etc.
on
Hmm.
that point, my lord,
Hmm.
my submission is that to claim minimum wages or the benefit of the minimum wages act, my lord, they will have to be in scheduled employment. And what is scheduled employment? That is described in the act.
This is not for you. This is for the state to urge. You are availing the services and you are washing your hands off by saying that they are supplied by the police. We have nothing to do. But the benefit goes to the Oil India, guarding your
My lord,
pipelines.
my lord, the money will also we pay to the police, not to them.
Ah.
Because since the police sends the, personnel, we don't say we pay directly to them. We send the money to the police only.
Hmm.
And the police in their turn distributes it amongst them.
All right. So let him come. Let us, or you want it on some other date?
Some other day, my lord.
All right. At the request of Mr. Dr. S. Dr. Leonard, Senior Counsel, matter stands appearing for the respondent Oil India. Matter stands referred to be fixed after 2 weeks, to be listed after 2 weeks.
Yeah, lordship, any date?
We'll keep it after 2 weeks.
7th of March.
7th. All right, 7th of March.
Obliged.
Mr. So and so appears for the writ petition.
Thank you so much. এই writ
Huh?
petition ৰ copy টো মোক।
এইবিলাক কি হ'ল? এজন হৈ গ'ল। আৰু নাই? Any other matter left to be done? Yes. এইটোহে মাতিব। হা? এইটো টাইম লাগিব। Dr. Saraf will just take up 1 or 2 small matters, then we'll call up your matters.
But he was available. Just 5 minutes back, lordship, he was available.
Who?
Mr. Devnath.
What is this?
My lord, regarding the pension, lordship. And that's it should arise, lordship, whether the past service of the petitioner before regularization can be counted for the purpose of pensionary benefit. My lord, the petitioners served from lordship since 1996. And service was regularized lordship from 1/6/2013. And he retired from service on lordship 31/5/2021. As a regularized lordship, he served 7 years, 9 months, 30 days. And before that,
You are referring to the counter affidavit of the
yes,
department?
yes, lordship.
Yes, take us.
Paragraph 11, lordship.
Paragraph 11.
They have clearly stated the lordship, everything.
You fall within that nine employees.
9.
Now the question is that you'll have to challenge that.
Whether it is a challenge is required, lordship, because under similar circumstances, lordship, there are series of judgment of the Honorable Supreme Court as our.
Show us.
Yes, lordship.
Show us.
My lord, in Doli Pujari case.
Hmm.
I will show you, lordship, just 3 judgment. My lord, division bench judgment of our High Court Lordship 2010 2 GLT, Doli Pujari, Bor Pujari case Lordship. Paragraph Lordship 18. May I read Lordship?
14.
Yes.
In Doli Bor Pujari case Lordship, paragraph 18.
My lord, we submitted an affidavit.
You're going to
In the present case, Lordship, yeah, paragraph 18. In the present case, the entire defense of the state is that appellant is not governed by any rules framed by the state under Article 309 and her service was purely contextual. The state also argued that the post which was occupied by the appellant for long 14 years was a temporary post and therefore appointment of the appellant was not in a vacancy which is substantive in nature and therefore the appellant is not entitled to the benefit of pension. We are of the opinion that the entire exercise of the state is an exercise in semantics. If the stand of the state is that the service of the appellant is not governed by any statutory rules framed under Article 309 and purely contextual, it is not understood as to how the appellant could be said to have retired on attaining the age of superannuation. Admittedly, no contract stipulating the age of superannuation is placed before the court. On the other hand, the appellant was made to retire on reaching the age of superannuation prescribed for all other employees of the state of Assam, whose services are otherwise regulated by rules framed under Article 309. If the service of the appellant is purely contextual, to our mind, the only known mode of putting an end to the service is either by a flux of time stipulated by the contract or by termination of the contract by an appropriate procedure. We are also not convinced with the submission that the employment of the appellant is purely temporary in view of the fact that the appellant was employed for a long period of 14 years. And since the retirement of the appellant, another person is appointed to the same post which was held by the appellant. Obviously, the work and the need to employ somebody to do the work continues. Employment remained contextual only because the state was either lazy not to frame appropriate rules under Article 309 or mischievously omitted to frame statutory rules governing the service of the appellant. In either case, it would be an arbitrary omission on the part of the state to discharge a constitutional obligation owing the article from Article 41 of the Constitution. Rules also provide for superannuation pension for such category of employee. We declare that the appellant is entitled to superannuation pension as she had served under the government in a substantive and permanent capacity for 14 years till she was superannuated. And in that case, in this case, Lordship, the service of contextual period has been taken into account. Now, Lordship, the Honorable Supreme Court
You're
judgment.
referring to another single bench judgment.
Yes, Lordship.
Mhm.
That is in
My lord, even I have
paragraph Lordship 29 and 30 in Habib Ali Borbia case.
Hmm.
it says that adult employees are not actually the
Paragraph 21. In the present case, the petitioner's temporary service was never regularized or confirmed. Further,
You're reading para 29.
21, sorry, Lordship, it will be 29.
29.
29, Lordship.
Ah.
In the present case, the petitioner had been working in a regular sanction post from 1966 to 1982 on temporary basis. Thereafter, his service was terminated and he was reappointed afresh on temporary basis after 5 years. The petitioner was made to retire on reaching the age of superannuation 14 years later. Rule 152 of the 1969 pension rule provides that a temporary employee who retired on superannuation would be eligible for a gratuity. This rule 152 has not been put to challenge, and as per the said provision, the petitioner who is temporarily employed can only be given gratuity. However, by following the judgment of the division bench of this court in Doli Borpujari Chopra, the petitioner's service can be treated to have been in substantive capacity inasmuch as the petitioner service has been under the government in a regular post and he has also been paid by the government till his retirement. As per the pay scale prescribed for a patuary, as such, proportionate pension can be payable to the petitioner in terms of Rule 108B of the pension rules. If the governor declares that the service of the petitioner shall qualify for pension in terms of the proviso to Rule 31 of the 1969 pension rules. However, there being a 5-year break prior to the petitioner fresh appointment as a patuary on temporary basis, white order dated so and so, the petitioner's service for grant of proportionate pension will have to be counted only from 11/8/1997 till the date of his retirement. That is 31/8/2001. Accordingly, this court is of the view that the disqualification under Rule 31 of the 1969 pension rule would not be applicable to the case of the petitioner hearing. In view of the above, this court direct the state respondent to issue a declaration in terms of proviso to Rule 31 of the 1969 pension rule to render the service of the petitioner from so and so to qualify for payment of proportionate pension. Thereafter, the pension will have to be paid in terms of Rule 108 of the Rule 1969 pension rule.
Yes.
Now, Lordship, the another one Supreme Court Lordship judgment, that is Prem Singh judgment, that I have given Lordship
What is this?
my Lord, paragraph 33 and 34.
Who has placed this instruction? Who has placed this instruction?
Later, my lord. Yes, my lord.
PNRD, who has placed this?
Yes,
What is
madam.
this?
Madam.
Yes.
These are the main objections for actually not granting. And the main paragraphs are at para 11 and 12. At page,
No, we can read all
88
that.
in it.
You tell us what you have to submit. Are you submitting anything there? Is it relying on certain judgments? Would you like to revert to this?
sorry, madam,
Is relied on certain judgments of this court?
he may be. I also have Supreme Court judgments, madam.
Yes, please.
I'll place them, madam. What the facts to put it is that in para 11.
Facts are very clear from your affidavit that some of the employees were given, some of the employees were not given.
Maybe, madam, wrongly, rightly, maybe, wrongly, right. Maybe. But there is a Supreme Court judgment, which is that no, ad hoc employees are not to be given.
Have you cancelled these earlier ones?
I have a judgment. I just place it before my lord and then my lord may.
No.
decide accordingly.
Have you cancelled the persons who, according to you, were not entitled?
As of not, I do not have any confirmed information, madam.
Hmm.
But just for the time being.
Because
let
your
me just
affidavit
raise
may-
this
has-
case.
Your affidavit has made a very clear averment
Yes,
that out of 51, GPF created in respect of 10,
yes.
NPS created in respect of 32,
So?
and remaining 9
Yes,
have not been granted. Who has authorized the government to create and grant GPS and NPS?
maybe right now just focus on the petition.
We'll record your submissions, we'll direct proceedings against your officer.
My
If
lord
you
may
want
do
to
that.
say, if you
I
want
have
to
no-
say,
No objection to that one.
no, if you want to
If my
say that
lord
this,
feels that
no,
my-
counsel,
my
kindly listen,
officer
kindly
is-
listen,
if
kindly
the
listen to the
officer
court.
is the-
Kindly
is the
listen to the
person-
court. Kindly listen to the court. You have filed an affidavit
Yes,
sworn by your officer. You are making submissions contrary to the averments.
no matter. I'm just trying to focus on the para 11 and 12 of the affidavit. Can you have a look at that?
Any judgments you want to submit?
Yes, there are.
Give us the judgments. We'll hear you.
They say there are ad hoc
You
employees.
submit the judgments.
And I'll do that.
Yes, please submit that.
Madam, can you have a look at para 11 of page 88 of my affidavit? In opposition. I'll have to speak about two paragraphs, para 11 and 12. 11 says that with regard to the statements made in paras 8 and 9 of the rate petition, your humble deponent begs to state that the petitioner,
We have read the paragraph, Mr. Counsel.
then my lord,
We have read your paragraphs 11 and 12, pursuant to which we put a query to you. You are relying on certain judgments. We are requesting you to give us these judgments
I have
and tell us
I have,
for what proposition you're relying the judgments.
I would not have a one copy actually. Wait. I just have a one copy. It just says that other employees cannot just dictate, to get actually.
What
always.
is this? This is an order.
From the Supreme Court, man.
This is a High Court order.
I'll give you a Supreme Court. What if my clerk is not correct in giving me the correct order? I have it, man. Yes. I did. I do. I do. Now employees cannot get this kind of.
Your affidavit says otherwise.
Maybe, Madam,
No,
fact is wrong,
No,
but
no, then what is the
legally,
purpose of finding an affidavit?
legally, this is the position as per
No,
Supreme
no,
Court
but
law.
this is your affidavit you're relying on.
My lord,
You have
as
asked the
per
court to
law,
go through para
this
11
is
and
the
12.
position as per Supreme Court law.
Then you withdraw that affidavit. You have not filed any application seeking withdrawal or modification. If you have, your officers have filed an affidavit according to you contrary to Supreme Court law.
Maybe, my lord, they are our law. So what, my lord?
Ah,
The laymen,
they laymen.
yes, they are.
Filed by an officer of the court under the signatures
My
of an
lord.
advocate.
I beg to just submit that not everyone is aware of all the laws.
Okay. Anything more you'd like to submit?
I only want to submit that this case doesn't deserve to be
Okay,
actually allowed.
Heard reserved.
My lord, just I want to lordship refer say rule 31 of the pension rule lordship regarding the condition of qualifying service.
We'll look into it.
My lord. Of the-
Pension
I'm
money.
preparing for respond number 6 and 5, Lordship.
Please give your,
Lordship.
fill up the cheats.
Yes, Lord.
Lordship, my submission is that letter, Lordship. I have already submitted.
And
Lordship.
ours also, Lordship, we have received no communication regarding it. I'm for the pension department.
I'm sorry for the pension. You know, it's very bad.
I've got the item.
Yes. FR 29. is it?
1 and 2.
29.
29, 1 and 2. In fact, for 29, 1 and 2 has given the instruction relating to passing of an order of relaxation of pay. It is not clear about the seniority, restoration of seniority. That is why that 1962 office memorandum perhaps that has been issued.
No, but where does it reflect that you will regain that seniority?
FR 29 doesn't indicate,
Doesn't reflect.
doesn't
Doesn't
indicate.
reflect.
That is why page 128 of the uh, repetition, Lordship will find that question was raised perhaps by somebody. Paragraph 2, it indicates certain doubts have been arisen regarding the consequence of an order of reduction to lower service, public or grade or post to a time scale. It has also been found that there has been no uniformity in determining the consequence of such reduction, whereas an order is asked, two questions often arises for consideration, namely, when should the government servant so punished be considered eligible for re-promotion? That is one issue. Second issue is our issue, my lord. How should the seniority of such government servant be determined on re-promotion? That clarification Lordship will find at page 130.
No, but there is a reference
In
to,
fact, I have submitted one apex court judgment, my lord. Lordship will
Mhm.
find same issue.
you take us to that particular office memorandum
Page 130,
in WPC
page
8036.
8036, my lord.
8036.
Page 128.
One 120.
Paragraph 2, that was the doubts, my lord. When a punishment is issued for lowering grade, post, or time scale. Two questions arose, my lord. One, when should the government servant so punished shall be considered eligible for promotion? That is one issue, my lord. Second issue is our issue, my lord. How should the seniority of such a government servant be determined on re-promotion?
You are reading 126.
128, my lord.
128.
128. 126 reiterates 128. It has discussed 128. The later OM, my lord, it is 14 May 2007. And 128 is of the original one, my lord, 1962.
Okay.
Affect school
It
development
includes service also.
lot.
Not only grade and pay, service and post.
In fact, what happened, that will amount if my seniority is disturbed, then it will be double jeopardy. And it will be, this is minor penalty. This falls under the minor penalty. If I lose my seniority, then it will be a major penalty. They cannot amalgamate two penalties. The
No,
wording is,
but what should have been done was to put your papers in seal cover until you
yes,
complete.
yes. In fact, in the impugnator lot, you will find, even they do not know what the DPC did. What I missed one DPC during my currency. They say perhaps it was considered. Because seal cover, if DPC again considers my punishment, then it will be double jeopardy. DPC will have to see my case minus the punishment part.
Yes.
May I
Did-
please, my lord? Basically, there are two instances in this case. In first one, my lord, the petitioner was prosecuted criminally when his wife lodged an FIR, and the same has been registered under section 198A of the IPC. And in that particular case, my lord, he got an acquittal. Subsequently, my lord, there was another departmental proceeding was initiated against the petitioner. What is the merit of that particular departmental proceeding? We are not concerned with that, but we are only concerned with the punishment.
If he comes within the zone of consideration,
Yes, sir.
his name ought to have been placed before the DPC.
Yes, sir.
But for the fact that he was undergoing a punishment,
Yes,
you do not consider him.
yes, sir.
What should have been done was to consider his case and place it in the seal cover.
Exactly. My lord is absolutely right. But that is the case of my learned senior. But that is not what fact reflects in this case. My lord, these are two independent things. Whatever penalty that has been imposed on the
Is there
petitioner,
a set of rules where it says that unless you suffer your penalty, you will not be considered for the promotion?
but my lord, I would like to point out one particular thing where when the penalty was going on in that particular period, in that particular tenure, the DPC has been held and DPC has approved the name of the petitioner for further promotion. So there is no vindictive measures. And my lord, there are two separate and independent things. First thing is whatever may be the outcome of the departmental proceeding by which he has been penalized. And secondly, my lord, his promotion is subject to his overall merit during his service tenure. When his SCR or
Where is the
ATR
recommendation of the DPC? Where
Yes,
is
my
that
lord.
recommendation?
I may be allowed to take, my lord, one of the paragraphs of my affidavit, which I have filed, my lord. My lord, may kindly come to my affidavit, which has been filed on behalf of the department. And now I would like to draw the attention of this honorable court to page 12 and para 18. It is relatively a long paragraph, but my lord, this paragraph clarifies the issue that is in dispute.
Para?
Para 18 at
18.
page 12, my lord, of my affidavit.
Yes.
May I allow to read, my lord? With regard to the statement made in para 13 and 14 of this writ petition, the deponent most respectfully states that the petitioner considered for promotion to the rank of deputy commandant by the DPC convened on 22/4/1997 for the vacancy year 1997-1998. But his assessment was deferred for the want of complete and up-to-date CR dossier. Subsequently, DPC of deferred case was convened on 25/6/1998, and he was assigned seniority below Sri Rajiv Kumar and above Rajiv Rai as per the seniority in the panel of DPC dated 22/4/1997 by Director General CRP order dated so and so dated so and so. As such, the petitioner's seniority up to the rank of Deputy Commandant was intact. Further, petitioner was in his zone of consideration for promotion to the rank of 2IC, second in command, in the DPC held for the vacancy year 2002-2003. However, as the petitioner was placed too low in the seniority, the vacancy, he was not promoted. Subsequently, he was considered for promotion to the rank of 2IC by the DPC held on 10/4/2003. The petitioner could not obtain prescribed benchmark that is very good. As such, the petitioner was assessed unfit by the said DPC. My lord, this is very relevant. He was again considered for promotion to the rank of 2IC by the DPC held on 26/4/2004 and 24/3/2005.
No, he was considered, but subsequently,
Huh.
his case is that because he was not considered in the earlier DPC, he's lost out on his seniority.
No, throughout the time, whenever the DPC has been held by the department,
Hmm.
he was considered for promotion, my lord. Throughout the time. And I'm proceeding further, my lord. May I kindly-
When was the punishment imposed?
Punishment has been imposed, my lord. Just a moment.
31/12/2013.
Hmm?
31/12/2013. Is 111.
31/12/13.
2013.
Page 23, no?
Yes.
Yes, my lord.
Continued till 31/12/2015, 2 years.
2 years. And the punishment that has been imposed by the department is the reduction of pay for 2 years. Now, to substantiate my point, my lord, may I kindly come to para 19 of my affidavit.
Hmm.
I'm reading para 19.
Yes.
That with regard to the statement made in paragraph number 15 of this petition, the deponent most respectfully states that, as already mentioned in the preceding paras, no discrimination was meted out to the petitioner and he has been assigned seniority strictly as per rule. As regards financial benefit and backward wages, is made clear that as per para 18.4.3 of chapter 3 of Swami's compilation on promotion and seniority, in such cases, pay is to be fixed under FR 27 at the stage it would have been reached. Had he been promoted from the date of officer immediately below was promoted, but no arrear would have been admissible. Hence, the claim of the petitioner now, my lord, the point I want to brought
Yes.
My lord, may kindly come to page para 20. This is another paragraph which is very relevant. With regard to the statement made in para number 16 of this writ petition, deponent most respectfully states that during the pendency of the disciplinary proceeding against the petitioner was considered for promotion to the rank of commandant. My lord, this is in the subsequent stage. Later to the stage of second in command. For the several times by the department DPC as such on 19/3/2010 for the vacancy year 2010-11, on 1/2/2012 for the vacancy year 2012 to 2013, on 15/3/2013 for the vacancy year 2013 and 14, and on 2/7/2013 for the vacancy year 2013 to 2014. My lord,
These are irrelevant.
No, my lord,
There he was not considered. He
No,
was
my
not
lord.
found fit.
He was not found fit.
He was not found fit. But subsequently, according to him, in the vacancy which arose subsequent to that,
No, in, during the period, during 2013, my lord, the departmental proceeding has been initiated against him. So his entire record has to be kept under seal cover.
therefore, was it kept under seal cover?
Yes, my lord.
Where do you find it?
My lord, I am coming to that, my lord. We have to go little further in this paragraph. All of whose outcome report was kept in seal covered, and finally on 18/9/2014 for the vacancy period 2014 and 15, where the respective DPC gave the outcome report of the petitioner being unfit.
No, 1 minute.
Yes,
What was kept under seal cover?
my lord, his
DPC minutes.
earlier we used to call ACR, but now we call it APAR, annual performance.
Whatever,
appraisal.
minutes of the DPC,
Yes, ma'am.
decisions of the DPC, insofar as the petitioner is concerned.
Yes, ma'am.
For which year?
My
In
lord,
the paragraph, you are saying
Ah.
that different DPCs on 19/3/2010, this is one DPC.
Yes, my lord.
For the vacancy year 2010-11, then 12/1/2012 for 12-13.
Yes, my lord.
15/3/13 for vacancy year 13-14.
Yes, my lord.
2/7/13 for vacancy year 13-14.
Yes, my lord.
Now, his case is that his punishment
Hmm.
was given on 31/12/2013.
31/12/2013.
Right.
But the proceeding has been initiated in the 2013 itself, my lord, DPC.
Mm.
So thereafter, even if DPC wanted,
Uh,
he cannot consider the ACR or APAR because a departmental
So,
proceeding has
so
been
you're
initiated.
saying
Yes, my lord.
that what is the outcome of these reports which are kept in seal cover?
Yes, my lord. If we go subsequently, the moment DPC gave the finding that the petitioner has been found guilty of committing whatever articles of charges that has been leveled against him, the moment they open up the seal cover, then they again found the finding of the review committee.
Where is that OM dated 14/9/92?
14/9/90.
Annexure P.
Annexure. And my lord, it is at page 61. And I think para number 2 is going to be very relevant.
Yes.
Para number 2, my lord.
Yes.
At the time of consideration of the cases of government servant or promotion detailing of government servant in the consideration zone for promotion falling under following category should be specifically brought to the notice of the departmental promotional committee. The government servant under suspension, the government servant in respect of whom a charge sheet has been issued and the disciplinary proceeding are pending. The government servant in respect of whom prosecution for criminal charges is pending. And now, my lord, I am reading para 2.1. The Departmental Promotion Committee shall assess the suitability of the government servant coming within the purview of the circumstances mentioned above, along with other eligible candidates, without taking into consideration the disciplinary case and criminal prosecution pending. Assessment of the DPC, including unfit for promotion and grading awarded by it, will be kept in a seal cover. So whatever has been done by the DPC, my lord, it is as per the rules and procedure that has been prescribed by the department. There was no procedural error or irregularity that can be found in the conduct of the DPC.
No,
That
but
my
this is in respect of only these three category of persons, and was he under suspension?
No, he was not under suspension.
Then, so number one goes, there was no charge sheet,
But
disciplinary proceedings are pending.
yes, my lord.
And then third is where the prosecution in criminal cases are pending.
No, my lord, may kindly see the clause 2 of para 2.
Hmm.
The government servant in respect of whom charge sheet has been issued and the departmental proceedings are pending. During that stage, my lord, departmental proceedings are pending. He may not be kept under suspension. It is altogether a different thing, my lord. But a departmental proceeding has been put to him At that time, he was facing the departmental proceeding. So we had no option but to kept his entire ACR or APR under seal cover. That is what make it obligatory by this office memorandum, my lord. And my lord may come to one more clauses that
3.1.
At page 62, para 3.1, my lord. May I read, my lord?
Yes.
If any penalty is imposed on the government servant as a result of the disciplinary proceeding, or if he is found guilty in the criminal prosecution against him, then the findings of seal covers shall not be acted upon. His case for promotion may be considered by the next DPC in a normal course and having regard to the penalty imposed on him. So all these procedural compliance has been taken due consideration of.
Yes, Mr. Sharma, 3.1. You are hit by 3.1.
If a penalty is imposed on the government servant as a result of the disciplinary proceeding, or he is found guilty of criminal prosecutions, the findings of the seal cover shall not be acted upon. His case for promotion may be considered by the next DPC in the normal course and having regard to the penalty imposed on him. My case is ahead of them. They found me fit in their no, in their 2015. 14 they didn't complete. The EP note itself indicated. They took into consideration the imposition of penalty, which they cannot. In fact, their office memorandum indicates.
No. 3.1. 3.1 says that if you are found guilty or if as a result of if there is any penalty imposed, the findings in the seal cover shall not be acted upon.
Findings will not be acted upon. Then what is the use of keeping it in seal cover?
We don't know, but this is what the
There is-
memorandum says.
No, my lordship will find when the seal cover procedure will come, 2.1 will come into force.
Hmm.
There is a restriction that three things under suspension, charge sheet, and departmental proceeding pending. 3 things. This is in respect of 3 things. Then how they will DPC will act. DPC will not see the criminal part or departmental proceeding. What was there? Because a separate proceeding is going on. DPC is not
No.
meant to do it.
You are referring to clause 2. Clause 2 is when your papers go into seal cover.
Yes.
There
Yes,
are
the
three
first proceeding.
categories. You fall into category number 2.
Right.
Now, the DPC concludes its meeting.
Lordship.
Let us say it finds you fit for promotion, which is put into seal cover.
Yes.
Now, pursuant to the disciplinary proceeding, some penalty is imposed.
Lordship.
3.1 says the findings shall not be acted upon.
Acted upon, it is during the currency of the
No,
penalty.
no. There cannot be currency because once the penalty has to be imposed only after conclusion of the DP.
Penalty period is there.
Correct. Having regard to the penalty imposed.
That is why the seal cover is there. Seal cover procedure is.
Seal cover cannot be acted upon in view of 3.1.
It cannot be, my lord. Because why they should not have considered it.
We don't know, but you are not putting to challenge this 3.1. You're not challenging this.
No.
3.1, you're quite right in terms of ordinary service jurisdiction. What is the point in what is the point in putting it in seal cover if you are not supposed to act upon it?
Act upon it.
But this is what exactly the memorandum says.
This paragraph 3, my lord. Main paragraph, on conclusion of the disciplinary case or criminal prosecution, which results in dropping of allegation against the servant, the seal cover shall be opened.
Open.
Yes, in case a government servant is completely exonerated due to determined in reference to the prosecution against him, the next the in the in seal cover and with reference to the date of promotion of his next junior on the basis of such position, the government servant may be promoted if necessary by reverting the junior most. He may be promoted notionally with reference to the date of promotion of his junior. Here, my lord, the case is squarely covered by my lord, apex court judgment. Apex court say that a person has been similar punishment, reduction of pay, then he
Then it
was-
requires interpretation of 3.1.
no, in fact,
You want that this 3.1 is in conflict with the very concept of seal cover procedure. That's your basic argument.
no,
Once the seal cover, once it is put in seal cover, which they don't deny,
Yeah.
your in respect of your findings, it was put into seal cover.
yeah, sure.
Then after the penalty is imposed after you serve out, it should have been opened. And if it was found that yes, you are entitled for the benefit, then you should have been given the benefit. But 3.1 says exactly the opposite. It shall not be given effect to having regard to the penalty imposed. Your penalty is for 2 years.
Right.
So for 2 years, it did not apply.
Here, I would like to rely on the honorable apex court judgment.
That is India.
Then issue, my lord, that case also paragraph 6 lord will find. That judgment was later on also relied upon.
Paragraph?
Paragraph 6, my lord.
But this is all right. This is what we would have ordinarily subscribed to, but for the memorandum.
Lordship, and the subsequent judgment also. It is there that
But has the memorandum been considered somewhere? You have not put to challenge. That has made all the difficulty.
the first judgment was relied upon, the last page.
This is on a different point, not on this issue.
And this 1962 office memorandum.
Your proposition is to interpret Rule 3.1, isn't it?
It was in fact,
You require interpretation of Rule 3.1. I'm sorry, the Office Memorandum Clause 3.1.
Got
In terms of the ordinary service jurisprudence, that once you put it into seal cover, you are supposed to act upon it. If he's entitled to the benefit, give him benefit with effect from retrospective effect. That is your case.
yes, and
But then how do you overcome 3.1 in the office memorandum? Unless it has been subsequently overruled or watered down,
let me Malad, take it up.
then you have not put to challenge.
Because that 62 office memorandum has been acted upon, has been discussed.
No, but has this been overruled, superseded somewhere?
Let me Malad, sometime now. Subject to
Heard, learned counsel for the petitioner. Similar prayer in the other one? Then?
I guess my lord had a pen. The same officer act as a reviewing authority, accepting authority, and the appellate authority. And under the office memorandum, holding the bill.
Okay. Let us pass an order here first. Heard, learned counsel for the petitioner, in this writ petition, the primary challenge is to the denial of the seniority of the petitioner from the date his juniors were given promotion. Stop. Learned counsel for the petitioner submits that in terms of OM dated 14/5/2007 and OM dated 10/10/1962, the petitioner was required to be granted his consequential service benefits, including area salary, promotion, etc. Stop. It is submitted that these benefits have not been granted as the petitioner was subsequently given promotion by which DPC
DPC of 2015.
in the year 2015, after he has served out the penalty which was imposed on him by the pursuant to the disciplinary proceedings initiated. Stop. The penalty was imposed on
31/12/2013.
19/1.
31.
31/12/2013.
13.
Stop. It is the submission of the learned counsel for the petitioner that this denial of his place in the seniority list is contrary to the office memorandums and will amount to double jeopardy, as the petitioner has already served out the penalty imposed pursuant to the DP dated so and so. And pursuant to the DP dated so and so. The punishment imposed in the DP was stoppage of 2 increments.
2 increments, my lord.
For 2 years.
For 2 years.
For 2 years, which has already been effected in respect of the petitioner. As such, after he has served out the penalty period, he ought to have been given the benefit of seniority, giving him his position in the seniority list from the date when his juniors have been promoted. Stop. Par contra, Mr. Deka, B. Deka, learned counsel, CGC, appearing for the respondents, has referred to the OM dated 14/9/1992. More particularly, clause 3.1 of the said OM, to submit that in terms of this clause 3.1, if any penalty is imposed on the government servant as a result of disciplinary proceedings, the findings of the seal covers shall not be acted upon. Such an employee's case for promotion may be considered by the next DPC in the normal course, having regard to the penalty imposed on him. Stop. It is submitted by the respondents that in view of this clause, pursuant to the petitioner's serving out his penalty, his case was duly considered by the DPC for promotion in the year 2015, and having been found eligible for further promotion, his promotion was accordingly granted. Therefore, his claim for seniority with retrospective effect, from the date his immediate juniors were promoted, while his penalty was, while he was serving out his penalty, is not available to him. Stop. Mr. S. Sharma, learned counsel for the petitioner, submits that he would like to revert back to the court as to whether the said notification dated so and so 1992 was still in force, or was it superseded at the time when the petitioner was denied his benefits. At his request and as agreed to by the counsels for the parties, matter stands deferred for 2 weeks. Yes, in the other matter,
Both the matters will be taken up together because
right, let this matter also be listed on after 2 weeks, both the matters.
and also sometimes we have not bearing.
But you don't want to argue the matter today.
But already the article takes the matter.
All right.
Deeply obliged, man.
We actually could have taken your matter in the first half because
Well,
all
I
the-
understand, but I
all
wasn't
the matters got adjourned.
compulsion. But on the last occasion,
Just 1 minute.
my
Yes.
on the last occasion, it made the submission before also that the impugned amendment by which it will be provided
Oh,
that all pending applications for extension of the eligibility period shall be deemed to have been rejected in violation of Article 14 of the Constitution of India. In as much as similarly situated industrial units, they are granted the extension and simply on the ground that the applications of the petitioners were kept pending cannot be a reason for denying the benefits to the petitioner. And since the equals have been treated unequally by putting a timeline, and the timeline, putting a timeline also, once the applications are pending before the authorities, the authority cannot say that we will not consider your application. And thereby all applications which are pending shall be deemed to have been dismissed. But the submission before lordship that not this classification which has been made between the industrial units whose applications were considered and orders were passed, and the industrial units whose applications were kept pending, has no reasonable nexus with the object sought to be achieved. And thereby, this classification which has been made between the two industrial units similarly situated is hit by Article 14 of the Constitution of India. Secondly, my lord, no reasons have been assigned in the impugned order as to why the applications which have been kept pending have been denied the benefit, whereas the applications which were considered and orders were passed have been granted the benefits. Now, the certain industries who were large scale and are now enjoying the benefit because of the orders passed on the extension before passing of the impugned order, and the industry like the petitioner who are similarly situated have been put in a difficult position because the petitioners will not be able to enjoy the benefits, whereas such leverage has been given to the industrial industry. Now, these were the submissions made before advanced before lordship, and mainly the judgments are on Article 14 of the Constitution of India. In fact, the lordship considered all the judgments in the earlier judgment when the lordship were considering the central excise, that the small scale industrial units which were entitled, not liable to pay the excise duty and were made liable to pay the GST, were denied the benefit of the budgetary support scheme. And the lordship was held in the judgment that this classification between the two industrial units is violative of Article 14 of the Constitution of India. In fact, the same judgments again I'm relying on in this case.
So according to you, in terms of the pre-amended position,
Right.
there was a benefit which had accrued to the petitioners.
Right.
And that was taken away by the subsequent amendment by way of a deeming fiction, which according to you is not
No.
permissible under Article 14.
Two grounds I'm taking. That first, that earlier the amendment, prior to the amendment, I was eligible
Hmm.
and that was a promise, and that benefit has been taken away.
Yes.
Without assigning any regions, and that is hit by the doctrine of promissory estoppel. And second one, the classification which has been made between an industrial unit whose applications were considered prior to the making of the order,
Yes.
and orders were passed in their favor, extending the eligibility period. And another type of industrial units, like the petitioner, whose applications were kept pending,
Yes.
and it has been provided for that all those applications shall be deemed to be dismissed, deemed to have been rejected. this classification is a reasonable classification and has no nexus with the objects for to be achieved. One cannot treat two unequally and grant benefit to one class out of the same genesis, my lord, and deny the benefit to another for no fault of the industry unit.
Yes.
In fact, the written submission which I filed, when the relevant judgments and all the relevant paragraphs have been reproduced about Article 14 and the Provisional Estoppel itself.
Okay.
And in fact, your lordship has also the occasion to consider all those judgments in the earlier judgment below. So I think even if I read those judgments again,
No, it's okay.
that will be simply wastage of your lordship's precious time. Only one thing, my lord, with the in one of the repetition, my lord, wherein the affidavit of position has been filed, that is WPC 1586 of 2021. My lord, here the statement has been made by the respondents that the application was rejected when it was Corona period. In fact, we have never received the communication. But since they made a statement that
Para.
in the affidavit, my lord, opposition, one five eight six. This is in paragraph number is not there, my lord, this is paragraph 8 at running page 236.
At page
Running page 236, my lord.
236.
Though we have not received the communication, but since it has been stated that the order has been passed prior to the amendment of the scheme, it will be necessary for me, my lord, to challenge those two orders. And thereby, my lord, this petition, your lordship may permit me to withdraw with liberty to file a fresh one challenging the post communication.
In this 1586,
My lord.
you want to withdraw it?
Well, because those communications, it has been stated that it has been, order has been passed.
But you have not received a copy?
We have not received the copy. But since it has already been passed as per the records, they have been given the number and all those things. We'll have to procure the copy and we'll have to challenge. Let me grant the liberty to me.
You only on this 1586.
Only one.
Okay. Very well then.
And rest cases, my lord, my argument will be treated concluded, my lord. So that
Yes, Mr. Counsel.
Lordship. If senior counsel is intending to withdraw the 1586 lordship, there we have filed only the affidavit in opposition, which we intended to rely on the other cases also.
We'll permit you to rely.
Only that portion.
Same affidavit you rely on.
Yes.
You serve copies on them.
Yes, yes, sir, we have.
Heard Dr. A.K. Saraf, senior counsel, assisted by Mr. P. Sharma. Barua, sorry. And Mr. Chaudhary, learned standing counsel, finance, taxation. This will be in WPC 1586 of 21, part of the series. Dr. Saraf submits that in this writ petition, an affidavit has been filed by the department, where at para 8 of the said affidavit, an averment has been made that the application of the writ petitioner therein was considered and rejected. Stop. However, it is submitted that no communication or order was received or served upon the petitioner, communicating the rejection of the application, of the representation. Stop. He therefore submits that since there is an averment made on oath that the representation of the writ petitioner therein has been rejected, he seeks liberty to withdraw the writ petition and file it afresh, if required, putting to challenge the said communication as well. Stop. Prayer made by Dr. Saraf is not objected to by the learned standing counsel, save and except that he sought liberty to refer to and rely on the affidavit filed in 1586/2021 in respect of all the other writ petitions. But then you'll have to file one affidavit.
Barring the paragraph that related to the petitioner in 1586, lordship, we can file it because.
Yes, Dr. Saraf.
I have no objection. They have chosen one because to file it so that in one it has been rejected, according to them.
No,
they filed
lordship,
one
the issue.
No, but according to them, this is the only affidavit. Now, even if we record, frankly, there will be no affidavit on record.
By removing the part.
He, however, submits that there is only one affidavit which was sought to be relied on by the respondents, reflecting their stand, and which affidavit was filed in 1586 of 2021. So, since that affidavit, since the writ petition is sought to be withdrawn at this stage, he seeks liberty to file a similar affidavit in all or any of the matters within a short date, to bring on record the stand of the respondents. Stop. Para, in view of the submissions, WPC 1586/2021 stands dismissed on withdrawal with liberty. The writ petition, the respondents are permitted to file their affidavit or affidavit within bracket S in respect of the other pending writ petition within a period of 2 weeks.
1 week, testing.
1 week.
1 week from today. Any such affidavit filed, copies thereof may be served on the counsel for the petition.
No, in other cases, you will also may report that the hearing has been concluded from my.
Yes, in respect of other writ petition, the learned counsel for the petitioner has concluded his arguments with liberty to give a reply if after submission of the respondent counsel if so required. Para. In view of the order passed today in WPC 1586 of 2021 and liberty granted to the writ petitioner to withdraw the said writ petition with liberty to refile the same if the occasion so requires, And also in view of the fact that the respondents had filed one affidavit seeking to rely on the same in respect of all the writ petitions, and the said affidavit having been filed in 1586 of 2021. Liberty is also granted to the respondents to file their affidavit in respect of the other writ petitions within a period of 1 week from today. Matters be listed
28,
for,
madam, 28 February. He has agreed.
for hearing, for further hearing on 28th, all right, 28th of February. Matter is to be kept as partner
For arguments of the respondent.
for the arguments of respondent. Yes. ये सब बंडल करके यहाँ
मैसेज कोई लोग